Right, back live with you tonight, Town in Focus, and thanks for staying on. Now, concerning turn of events, the Electoral Commission of South Africa has been found to not have enough, or let me say adequate control measures in place to protect sensitive information at its disposal. According to the information regulator, the IEC, WhatsApp LLC and Lancet Laboratories were amongst those found to have breached the Protection of Personal Information Act. Advocate Collen Weapond joins us now, Commissioner with the information regulator. Good to have you, Advocate, and thank you very much for your time and coming on this evening. In the period under review, at least since April, you would have issued 4 enforcement notices. Is that a good number in the space, or is it an indication of improvement in compliance in this space?
Thank you so much. Good evening to you, Mr. Mdluli. Good evening to the viewers. So that's a very interesting question, because the information regulator is actually still in a process of establishing what would be the accurate and most correct baseline. But 4 enforcement notices being issued is an indication there is non-compliance, definitely. And those non-compliances obviously should be corrected by those institutions that are non-compliant. Yeah,
that institution, one of them at least being the IEC. This after, of course, we saw that breach, which they would have said happened because a junior staff member would have had access to the computer with the information of the nomination list of the ANC and the MK party, and then that ended up having been leaked. What did your own investigation reveal?
No, that's exactly what we found. We found that users were not limited to those that are restricted to receive the specific information. So all the users had the access. That was actually problematic, because you should restrict the access to specific records or data or information sets to those who are actually entitled to use it, and that we found was not in place. The second thing is that the security policy of the Independent Electoral Commission, or the IEC, was also not updated, and the practices of this restrictive measures and the practice of ensuring that there are adequate control measures in place was actually of concern to the information regulator, to the extent that we also said that there's also this practice that you are referring to that was also not embedded, especially with regards to your senior staff, your senior managers, and your exco. That practice need to be embedded in those at those levels of management, to ensure that there is a restriction, but also lower levels must also be restricted to those who are actually required and who are authorized to have the access.
Yeah. Are you comparing, for example, that particular standard to other electoral commissions? I'm asking that because in the case of WhatsApp, for example, you would have looked at how Europe users are protected compared to what the African users are getting as an experience, yet the standards are the same in terms of the general practices of protection that should be put in place. Are other electoral commissions, for example, in the world, using a separate standard in terms of the protection of that kind of detail?
No, that's quite an interesting question. So in this instance, we did not do a benchmarking exercise to compare what the IEC is supposed to have in place in comparison with other authorities that conduct elections. But what we can safely conclude is that the IEC, on its own accord, in terms of Section 19.3, is supposed to comply with generally accepted practices and industry-specific practices. Now, those would be your ISOs, your ISO standard 27001, and those in particular have certain measures that are supposed to be put in place, and one of them would be the fact that you must update your security policy regularly, and you must also ensure that access is restricted to those who are supposed to have access.
Yeah. Section 22 notification seems to be an all-round non-compliance, at least with the four that you would have cited in this particular report. What is so hard to understand about this Section 22 notices?
Yes, so I think we are still in the beginning stage, and at times there are steps that the responsible parties like the IEC would miss. So in this specific instance, the IEC's notification was not complete. It did not cover all the requirements of Section 22, and hence we were saying that because the Section 22 notification to the information regulator was not complete, they should review and update the Section 22 notification, and then ensure that they publish that specific notification on their website, so that the affected parties must take adequate steps to protect their personal information, which was exposed by the IEC.
Yeah. Is this something now, this particular enforcement notice, something that can be challenged, taken on review, something that can be appealed to say, no, but our security systems are well in place. They're not compromised at all?
Yes, of course, Mr. Mduli, because you would know that the Section 20, the enforcement notice that the information regulator has issued to the Department of Justice and Constitutional Development, as it was called then, is currently in court. There's a review of the enforcement notice that was issued, as well as the infringement notice that the information regulator has issued, because we have in our infringement notice issued a fine of 5 million against the Department of Justice at the time.
You've now also found, as I mentioned earlier on, some discrepancies in what WhatsApp is doing to its African users compared to what WhatsApp is doing to its European users. Expand a little bit on that difference.
Yeah, so what we found, and this is quite a unique situation where the users in Europe was afforded a higher level of protection in terms of what the policy is providing for the WhatsApp policy, LCC, and other users outside of Europe, which then points to South Africa as well, were afforded less protection. And one of those examples that I can refer to is the fact that we know that you are forced to comply, and that is then what we would call a contravention of what we would call consent, because consent is defined as an explicit, specific expression of will, and which is voluntary. But in this instance, if it is forced, either you comply or this happens, and then it means that in that specific instance, the consent is actually not complied with in terms of the definition and the standard. But very importantly, there's forced compliance, and that in itself is a grave concern for the information regulator. And the information regulator is also of the opinion that the same level of protection that are afforded to European users must be afforded to users outside of Europe, which then includes South Africa.
The argument that the Promotion of Access to Information Act does not apply to its social media network, which is extraterrestrial. How do you respond to that argument?
Yeah, so for us, it's very important just to understand and take one step back that for a institution that's got a footprint and that conducts business in South Africa, surely and most definitely that's got a presence in South Africa should then comply with the provisions of PAIA, and that is the view of the information regulator. And we have also, by the way, and this is very important to mention, assessed other social media companies who's got a global reach like your TikTok and Google, and they have not indicated that PAIA does not apply to them. But in that specific instance, WhatsApp raised a jurisdictional issue But we are of the view that if you conduct business in South Africa and you've got a presence in South Africa, it means that you can be subjected to the laws of South Africa, because we should then assess if you are complying with the legislation that was issued by the government of South Africa.
A lot of us, and you would know, during the COVID-19 period, would have used the Lancet Laboratories services to get tested. How did they not comply with the regulator?
Yes, so what is interesting is that in the case of Lancet, they did not report the security compromises at the time that it occurred. And so that delay is actually contravening what the information regulators say, that you should notify it within reasonable time. And reasonable time would usually be a period that does not exceed 3 days, at least 72 hours. But in the case of Lancet Laboratories, they've waited and then they've reported those security compromises in bulk to the information regulator, which then contravened the requirement that you should report that specific security compromise within reasonable time, which would then be not more than above the 72-hour threshold, because that is important for us, unless if there's clear evidence that the South African Police Service have advised you not to report the matter at the time within the specific period, which is the reasonable time period that I've just described. So that in itself is of particular importance for us, that there must be compliance and institutions must report security compromises within reasonable time.
Yeah. One of the institutions that I found is actually a municipality, the Blouberg municipality. What sparked interest in that particular municipality that you went and investigated it? Or do you generally look at all municipalities and see how they conduct themselves as far as how they keep records?
Yeah, so in this instance, and this is very important, there was the unlawful processing of personal information of a former employee, and their personal information was exposed on the internet, and that specific declarations and submissions that was made was then open for everyone to see. And that personal information then could compromise actually that specific data subject in various ways. So the information regulator then found that there was a compromise of that specific former employee's personal information.
Yeah, that's interesting, because we live in a time where a lot of whistleblowers are exposing information on the internet. So you could be a government employee caught up in some kind of maladministration, and the paper trail could be released, for example, on social media, even to us as the media, of that particular transaction. Are you saying municipalities could find themselves in trouble if that would happen?
Yes, of course. And the problem that we have is that if a whistleblower's information, personal information, is exposed, there are grave concerns. And we also know what has happened to, in the instance and in the case of Babita Deokaran, the chief director in the Department of Health, who was actually responsible for allocated the duties of the CFO. And that in particular could compromise the safety of various people. So what we are saying is that all personal information, including those of whistleblowers, should be protected, and there should not be any exposure. And for this, it's also important to note what aspect of what happened to Mr. Kania, who was also killed in that process. There was also a compromise of his personal information.
Yeah. I suppose a lot of people, when the regulator was introduced, they thought, look, we are going to stop getting spam calls from direct marketing companies. And unfortunately, it has not gotten any better. In fact, others might tell you it has become a little bit worse. Why is your guidance not being noted?
Okay, so during July 2024, we shared a draft guidance note what our stakeholders that are in the direct marketing sector. That would have been your DIMASA, Direct Marketing South Africa. We also shared the specific guidance now with the Banking Association of South Africa and various others. Stakeholders, but we then had to work on the comments that we've received on the draft guidance note. And Monday, which is the 9th of the past Monday, we managed to, on a line-by-line approach, consider all the different comments that was provided by DIMASA as well as Banking Association of South Africa, because our chairperson has a quite strict approach with regards to how we approach and consider the comments. And only now, Mr. Mdluli, will we be able to have what we would call a stakeholder engagement session on the 25th of September, and we will then have that guidance note finally considered by the stakeholders, and that guidance note will then be the official guidance that we provide. But very importantly, on your point that our guidance was not taken seriously. So there is a misunderstanding, and this misunderstanding is from the responsible parties, those who are engaging in direct marketing practices. So first of all, you cannot obtain the personal information of the person that you are going to call from a source other than himself, unless if you comply with the exceptions and if it's lawful, for instance, if it is obtained from a public record. But very importantly, the second thing that a responsible party should do is to call you. And when they call you, after they've obtained your information lawfully, is to ask if they can market to you. And if you consent, they must also specify the products that they want to market to you. And if you withhold your consent, they are not supposed to contact you again. And what they should do is to put your name on the do not contact list that they should keep, and that should then be the basis of engaging. Failure to do so will then be a contravention of Section 69 as well as Section 11.3b of POPIA.
Yeah. What is going to happen with this interpretation of electronic communication? You're going to need a court of law to finally give a proper definition, because I believe there's contention of whether a direct call also constitutes electronic communication.
Well, thank you so much, Mr. Mdluli. The regulator is quite clear, and the chairperson have articulated this position at various platforms. So we, at the information regulator, have the view, and we are we consider this view multiple times, that the telephone is actually forming part of electronic communication. And this is a very important point. And we are also saying that, and we are not discouraging the use of direct marketing practices, but what we're saying is that all institutions should comply. But the very important point that you raise, because there are differences in the interpretation or understanding, and really the difference centers around store and retrieve. And we are saying that looking at a telephone, there is what we would call store and retrieve, and it complies with that specific principle. But obviously, there are different views, and those views might in future have to be considered. If there is such a dispute in a court of law, and that dispute would then have to be confirmed either by a specific judgment, but also we are of the strong opinion that a telephone forms part of electronic communication.
Advocate, I appreciate your time. Thanks so much for coming on. That's Advocate Collen Weapond there joining us. He is the Commissioner at the Information Regulator, following that latest report under review of those 4 particular companies and some of those issues that they're dealing with as far as the keeping of your private information is concerned. Of concern, of course, is that the IEC has found to have had systems that are not adequate in protecting personal information.